medical admission, sir.
Oh,
Actually, I filed it yesterday, but it's not been listed today.
yesterday?
On
Yesterday was Sunday.
Saturday.
Saturday.
I'm
Okay.
sorry.
Yes, we'll take it up. Yes.
Acha, bhai.
Tomorrow. All of you are getting up now, right? After judgment is delivered, everything. You will have to answer what you have been doing since then. From 2nd of August, what have you done till for 1 month? Please be ready. We are passing an order in today's case, which will apply to your case also. Tomorrow.
Matter pertains to DRT. The matter was matter pertains to DRT and the
Fresh matter.
no lot. It has been dismissed due to the non-representation. It has been dismissed due to the non-representation of the association. We are the request to file for tomorrow.
You have filed an application for restoration.
Tomorrow, so that
Restoration you have filed.
we are filed.
DRT matter means you know what is Satyavati Tandon. We will relegate you tomorrow itself to the remedy. Be ready. Yes. Yes. Tomorrow.
Medical admission, Friday,
You want when? Today, tomorrow. Yes, please be ready, Mr. Nobody comes prepared. We are telling you, putting you to notice. You are approaching this court after 1 month. You will have to answer this question. Nobody is prepared. We are sure nobody has brought the case law. We will decide it today. That decision will bind you also tomorrow. When do you want? Tomorrow? Tomorrow. Today?
Friday, but
Today. So have you prepared, madam, what you have been doing for 1 month? And how it can deprive you of getting relief? Please get ready.
PG medical admission, last date of joining in tomorrow, Milad. Earlier to them, beach of
Tomorrow.
today, maybe please to Milad, because tomorrow last date, Milad, joining.
All right, let's see. Fresh fighting, Mr.
No, Milad, earlier division bench of Kisanogo court.
Then, Mr. You, please, what were you doing? You knew, when did you know that last date is tomorrow?
Yes, 31/8/2023. I
You
know
knew.
Milad. I downloaded on 1/9/2023. So that Milad.
But we will take it up tomorrow. We will permit you to join. There is nothing. If because Mr. Rao has to be put to
Yes,
he must not have brought the file also. How can we take up today?
Already
Only those matters today will be taken up of which Mr. Rao has noticed.
I have already informed him.
All yes. Tomorrow?
Pick up tomorrow.
Tomorrow. Yes.
In fact,
All madam.
for tomorrow, medical admission matters, your lordship. Seeking for tomorrow.
Get ready. The question of delay in approaching the court. Fine. We are putting everybody to notice, right? You just come like this, and at times you don't know what is the prayer also. Please.
Tomorrow.
Lordship say in my matter, Milad, covered judgment of Honorable Supreme Court.
Sorry, what? This is PG is done, right? Tomorrow. PG, your PG matter is tomorrow, right? Then what is somebody, some other mention memo? Arey, Mr. Prabhakar, you made a request for PG. It is coming up tomorrow. Then what else? Covered by Supreme Court, which judgment?
WP number 944 of 2020.
Another mention.
Yes.
We will take it up a little later, Thursday. Thursday is a holiday.
But last date of joining is only tomorrow. So that
We have granted tomorrow, no? So we have only one mention memo.
only one.
So coming up, we told you tomorrow. Yes. 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 Check. Yes, senior come.
Pass on this, sir. Small synopsis and chronology, my lord.
No, nothing, no synopsis. It is admission. And you say that this WP is pending before single bench only.
It is not listed till now. I just pass on that.
No. WP 913, it's an interim order deferring the proceeding, obviously under a misconception of fact that WP 913 of 21 is pending before division bench, which is not so.
Not so, Mara.
So then you bring this fact to the notice of learned single judge. We will request him to pass appropriate orders.
I leave it.
Let's think,
Because
yes.
only
This
thing, my
intra-court
lord,
appeal.
posted along, I just pass on synopsis. That's 913, my lord, is yet to be posted before the division bench as per the orders of the registry.
Division bench?
It has not yet been listed. It has been
No, no,
referred.
what is your point, mister?
But
You have taken a point that 913 is in fact before single judge, which the single judge has
not
not
yet been
taken note
listed.
of.
It's not yet been listed.
It
That's
is
the reason I just passed on the synopsis, my lord.
What synopsis, mister?
Why you have asked for it is that especially the third page, where chronology.
No, no, no. The only question is, mister, we are senior counsel, whether 913 is pending before division bench or single bench. From the memo of appeal, if you have seen, whosoever has settled, you have taken a ground that 913 is before single bench.
Lordship may.
So we will,
I'll appropriate.
yes, we will say so.
913 is before division.
This intra-court appeal has been,
913 is before, it is a reference, Milord. There is a reference.
I
to
say,
division
that's the
bench
reason
in
I
913.
stated so in my synopsis that 913 honorable learned single judge on earlier occasion synopsis dates were at third page. That it was referred.
but you said single bench.
Yes, sir, that's the reason, your lordship is. You may see page 3 where chronology.
At least, mister, on facts, there should be no
but
variance from
that's true, but
when a senior counsel is appearing. That's what we
That's the reason
expect.
I put chronology and passed on.
Treated as.
Item 6, my lord.
Where
Record
is the order of reference, Mr. 913? Order of
I am not
reference.
the petitioner, man. I could not get a copy.
Where is the order
I
of
am
reference?
also not the.
We are not the petitioners.
What basis you are saying that it has been referred to division bench?
That is mentioned in the order, and you will actually see the synopsis
No,
point.
no, no. He is saying that it is pending before single bench. You are saying it is before division bench.
They are also
So
saying,
if you are proceed, tell us. Then you said that it's a reference. So please produce a order sheet of WP 913 to show that it is pending before division bench.
6 Milord, you will actually
This
kindly
intra
see 6
appeal, this intra-court appeal, unfortunate, mister. Simple question you are not.
6 Milord, that is what.
Six is the order.
6 in the synopsis that is furnished by them. It also shows
Mister, what did we ask you?
23/2013, there is a reference order. That is what is mentioned by them.
When it's a reference, then mister,
Yes.
Well, at my
what
submission,
is wrong with the order?
it is
You
not.
file an application before single judge.
Appropriate clarification, I'll seek it.
This mark the presence with consent of the parties, matter is heard, condone delay allowed, then with consent of the parties, matter is heard finally. This intra-court appeal has been filed against an order dated 14/7/2023 passed by learned single judge, by which learned single judge has deferred the proceeding in the writ petition till decision of WP number 913/2021. Learned, so the senior counsel for the appellant submits that by an order dated 20th March 2023, learned single judge 20th March 2023 passed in WP number 913/2021, the learned single judge has referred the matter for to the division bench. However, till today, the matter has not been listed. Full stop. He submits that he be granted, learned senior counsel for the appellant submit that the appellant be granted to submit an appropriate application before the learned single judge. Full stop. In view of aforesaid submission, the appeal is disposed of with the liberty to the appellant to move an appropriate application before the learned single judge. Yes, next.
May I please, Your Lordship? Well, petitioner is the appellant. The petitioner is the appellant before the Your Lordship.
We know it.
Yes.
Ah.
The order passed on 16/6/2023 has been vacated by an order dated 8/8/2000.
Who appears?
I'm appearing behalf of the 1 to 3, my lords, respondent corporation.
My lord, I'm appearing for respondent number 4, my lord.
What happens if I stays vacated his petition right? He should live without electricity, right?
My lord,
Because he is not the owner.
my lord, may I submit this?
This is not the this thing, mister. Right to electricity is one of the basic facets and forms integral part of Article 21.
My lord,
This you may be the owner, that fight it out with him in civil suit.
Yes, because
may I two two submissions,
Yes,
my lord, then I leave
please.
it to your lordship.
Please.
We are brothers, my lord,
Ah,
and we
very
are
good.
partition.
Ah.
But, he being elder, my lord, he occupied my property. My lord, when there is a confusion, I approached this court, my lord, and got it surveyed. My lord, at the time of taking,
You know, we are assuming for a moment that he is a rank trespasser. You are the encroacher. You are the owner.
no, my lord,
That doesn't affect his right to seek electricity.
Not,
You can evict him in accordance with law.
my lord, that doesn't stop there. My lord, he digs a borewell. He goes to electricity department. He gives an undertaking saying that this
He-
bore-
You are the owner, right?
yes,
He is in unauthorized possession.
yes.
You can you throw him out with the help of police authorities? No.
I am not throwing out.
So then take recourse to law. So
Not-
long as he is in possession, in our opinion, he has a right to seek electricity. Seeking an electricity connection does not create any title in favor of anybody. We will clarify this.
Lord, I'll accept that. My lord. He gives an undertaking saying that this particular borewell,
He has given, we have seen that.
Lord, something obtained under misrepresentation and
If
suppression.
there is any objection, the authority can cancel. This is the undertaking furnished by him.
My lord, he specifically says this particular borewell is in survey number so and so. If any objection is there, I will be liable and service connection may be disconnected. This is undertaking on the basis of that undertaking.
No, no, he had applied for survey number 492/2 and connection has been granted 492/2 only.
Yes, my lord, in the affidavit, he says it is in 491/1. In the suit, he says it is in 491/1. My lord, a person.
Yes.
My lord,
You also know the legal position, Mr. If you
Yes,
want to
well-
argue. We
my
will
lord,
hear.
I am not arguing for the purpose of argument. I am only placing this before your lordship. Sir,
Undertaking.
my lord,
We have understood he is bound by his undertaking. Therefore, no electricity connection can be provided to him.
my lord, a person obtaining something under suppression and misrepresentation, my lord, can he be allowed to do that? Only my submission, my lord. Beyond that, my lord, I-
Without the presence. With consent of the parties, the matter is heard. Finally, this intra-court appeal has been filed against an order dated 8/8/2023 passed by learned single judge by which stay granted in favor of the appellant on 16/6/2023 has been vacated. Paragraph. Facts giving rise to filing of this appeal briefly stated are that the appellant stroke petitioner filed a writ petition seeking a direction to respondents 1 to 3 and respondent number 5 in the writ petition not to disconnect electricity supply to the petitioner service connection. Full stop. The learned single judge continuation. The learned single judge by allowed to he cannot cause damage to his standing crops. Full stop. Therefore, the learned single judge in the peculiar facts of the case ought not to have vacated the ad interim order. Full stop. The interim order. Full stop. The paragraph for the aforementioned reasons, order dated 8/8/2023 passed by the learned single judge is set aside. The official respondents are restrained from disconnecting the electricity supply to the premises in question during the pendency of the petition. Full stop. It is made clear that observations made in this order have been only made for the purposes of deciding this appeal and shall have no bearing on the writ petition which is pending before the learned single judge for adjudication. All the contentions all contentions are kept open, which can be which can be raised by counsel for the parties. Accordingly, appeal is disposed of. Yes.
But may I make one request, my lord? Lordship may also say suit, my lord. Suit is also pending. Please appeal.
So the right to, you have written is fundamental part of this thing. Mere grant of electricity connection has no bearing on the question of in respect of the property, which in any case is pending adjudication of a suit. Pending adjudication in a suit. Next.
Oblige. Oblige.
Yes. Yes, Mr. 6 September.
Yes.
This matter is coming up 32H. Mr. Rao,
Yes, sir.
6 September.
It's maybe tagged along with those matters. And there
You
is an
have
ID
the
in those
order?
matters.
Order. This order you want to be passed,
Same order may be passed, my lord.
which there is an interim order.
Interim order is,
Interim order is there.
I have filed, my lord.
That interim order we will pass. Sake of which page, Mr.
My lord, page number, my lord.
Write everything, madam. Interim order.
97.
This is the interim order and list on 6th of September 2023 along with WP number 23100/23. You will have the order, right? I'm keeping it.
Obliged, my lord.
Which other case, Mr. 32H is item 7, Mr. Prabhakar?
Seven.
Huh?
Seven.
Item 7 also this order. 7. Yes. Next.
May I please, my lordship? Medical admission matter, my lord.
Yes. Yes.
My lordship,
What is the prayer?
prayer is
No, you will have to answer all this bunch we cannot entertain, Mr. Right? You have pleaded in the petition that on 2nd of August 23, you were declared as non-local candidate. Why were you waiting till 31st of August to file the petition? Delay of this this magnitude of 29 days in academic matters where everything is time bound is fatal. And in our opinion, you are not entitled to, prima facie opinion, you are not entitled to seek the relief claimed in WP. Please tell us what is the law.
my lordship's petition is my lordship's petition is a student, my lordship.
The student can do anything, right?
My lordship,
And you can seek admission in the month of December also. Why have you come? You have come a little early.
my lordship may consider
No consider. We are passing an order. This can't be done. Yes.
Even on merits also is not entitled.
See, you should see. This action is published. In 2 months. There is no representation. We have taken a similar view. I was part of the bench which had passed an order in Karnataka. I am bound by my own view. We are referring to it also. And apart from that, Supreme Court decision also. Yes. Yes, madam. Petitioner is an petitioner with consent of the parties heard on the question of admission. Mr. Rao. Yes. In this writ petition, Mr. Rao for respondent number 2 and 3. In this writ petition, comma, the petitioner inter alia has prayed for the following relief. Quote. Paragraph. The petitioner had appeared in the NEET undergraduate examination which was held on 7th of May 2023. The petitioner was declared successful in the aforesaid examination and had examination, full stop. The petitioner was treated as, full stop, from the averment made in para 5 of the writ petition, it is evident by the petitioner, from the averment made in para 5 of the petition, it is evident that petitioner was declared as non-local candidate. Paragraph 5 of the petition is reproduced below, extracted below for the facility of reference. Quote. Para 5, you first write, delete, what is the sentence? Delete. Para 5 of the writ petition reads as under. Quote. Thus, line below, thus it is evident that the petitioner was declared a non-local candidate on 2/8/2023. Full stop. Then when that petition was filed, will you get the date batch 33B? Right? The students, the students who are similarly situated like that of the petitioner filed Zero. Full stop. And UP Power Corporation versus Ram Gopal 2021 bracket close 13 SCC 225 paragraph. We are aware about the paragraph, delete. The normal rule is that when a particular set of persons are given relief by the court, all other identically situated persons need to be treated alike by extending that benefit, and not doing so would amount to violation of Article 14.
Mine also same notes.
That he is not entitled to similar pay. See, problems that so let's say that's why. Yes. Yes, 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 madam.
May please your lordship.
Yes.
Sir, I am the petitioner. Your
What is the relief?
relief is the only to admit, declare me a local candidate in B category and C lordship. Because I was already allowed in A category, that is convener category, sir. In writ petition 22038
No,
of
no.
2020.
So when were you declared non-local?
I was declared prior to my writ petition, lordship in this
When
matter.
date? This all missing in the rate petition, Mister. We go through the rate petition. That's why it is as vague as possible because it's inconvenient for you to plead the facts.
Yes, sir.
So you are missing. When did you? Same principle applies. When were you declared as non-local candidate?
26 lordship.
Huh?
26/8.
How?
Thereafter I filed
No,
a
no, Mister.
22038.
Please appreciate. If, I mean, the just petitioner in previous case was declared as non-local on 2nd August, right? The list was published. You are not an exception. You can't be treated as on 26/8. You must have been treated on 2nd August also. So, no, fill an affidavit, Mister. Along with the communication that you have been treated as non-local. Affidavit.
Yes, yes, lordship.
Date you have not been given.
My writ petition already allowed and I was allowed as a local candidate. That is
Last candidate is, my lord, he wanted, my lord, the 85% reservation in B category. B category, there is no reservation. It's a management seats. Where candidate from all over India are eligible to compete B category seats. He want a special case, he should be treated as a, my lord, a local candidate.
No, this is local candidate in this.
B category.
B category.
You are not.
They want exclusive order from the honorable court.
No, no. Which provision prohibits them from this thing? He has not challenged.
My lord, notification is there, my lord. 114 where the rules, my lord.
So how contrary to rules a relief can be granted to you unless you challenge the validity, Mister?
Yes, lordship. Entire
Which rule? Mr. Prabhakar, which rule? Mr. You have not challenged the rule. We will dismiss the petition saying that in view of this rule, you are not entitled to be treated as local candidate and you have not challenged the validity of the rule, therefore no relief.
That is the B category, lordship. First
Whatever category.
A category I was allowed. I was allowed as a local candidate to the admissions. And from
There is Mr. Read prayer clause. You have not anywhere said that B category, C category.
yes,
Read. This is what is most confusing here, that half a page prayer doesn't make sense because your distinct typist or the person who has typed this petition has typed the relief. You have not chosen to read it even today. Please read. What does it make sense? Read again. For our benefit, we have not read it.
yes, it is further pending disposal of.
No, it is there for
Yes, it is there.
page 10. In page 10.
Right, and honorable court may please to issue writ order direction, particularly in the nature of writ mandamus, to declare the action of the respondent number 2 not consent in petition as a local candidate in Telangana state as per rank shown in the merit in the connection with the NEET admission petition as illegal or arbitrary. And so articles of 14, 19, 21 in India. And consequently direct the respondent number 2 herein provide the admission to the petitioner by consenting him a local candidate B and C categories.
So what is B category?
B category is the management category. And C also category.
C is what?
C is the more cost than the B, sir. More cost than B.
NRA category.
That is NRA and
NRA. So what is the requirement? Which rule, Mr. Prabhakar Rao?
Right now, I do not have lots, but kindly put it tomorrow.
plus.
No, if Mr. Please examine. You must have been, is it your case that under which rule you are entitled to be treated as local candidate?
In 3 lots. 3. Roman 3.
Roman 3?
Yes.
And so then the division bench decision is against you. We have already held that
Yes.
division bench decision is against you. We have held in that division bench decision that none of the cases of the petitioners fall under rule this thing. Until you challenge the validity of rule, you cannot get anything.
The last application, not the writ petition 22038.
Mr. Rich, we are not, please understand that we are not sitting here to convince you. Our job is to pass an order.
Yes.
Take a flight to Delhi. We will make the order available to you. Correct? We will dismiss it saying you are not telling us the rule. You are not you have not told us when this thing, you are treated as non-local candidate, this query you put, you did not answer. There is no material. You didn't say that I will place it on record that on 26/8 I was declared as non-legal. That is you are not doing except for making verbal submission. Secondly, which rule you are entitled, you don't know. Then thirdly, that rule you have not challenged. What can be done? Thank yourself for drafting such a petition.
Tomorrow,
And go to Delhi then. Let him go. What to do? This is all vague, not orally telling, not answering.
no, my submission, Lordship, I was already declared as a
That's
local
why
candidate.
when we say that we will dismiss you, immediately understand. So long as we are trying to tell you that please amend the petition, challenge the rule, you don't get it. The moment we say that we will dismiss, immediately you understand what is to be done.
Yes, Lordship. Tomorrow,
Not the presence.
I will amend the minutes. The permits that
We,
come.
from perusal of, we have heard learned counsel for on the question of admission, petition is admitted for hearing. Notice. Yes.
Public.
Yes, madam.
Yes. Madam.
The petition is filed, agreed by.
No. Again, madam.
So medical matter.
When,
Hello?
what was the last date of uploading?
Last date of 27/10/2022, madam.
First phase of,
Madam.
he did not exercise, my lord.
22, how can,
My lord,
he doesn't know.
she did
what-
not secure the sponsor letter within the time, my lord, so that he.
Madam, we have gone through your petition. What was the last date for uploading the application? That is missing. And why you did not upload it, that is missing. Student MBBS is all right, but students have to participate in the examination as per the guidelines framed by the university, right?
Yes, my lord.
So you, all others uploaded, why you didn't upload? What is the date? When have you filed the petition? This is all vague, madam.
We have
The
uploaded.
petitioner should thank for engaging you. This is all. What is the last date of uploading?
My lord, petitioner has made a representation letter along with documents, my lord. Representation letter is in page number 22, my lord.
23 paragraph.
It's a covered order, my lord.
You don't, you haven't read, madam, the petition drafted by you.
My lord, kindly post it tomorrow, my lord.
paragraph 5 you have said that it's 12.8. Brother is pointing out you don't read your petition itself. What pity? What a pity.
I have read my lord, 12/8/2023 last.
So why you did not upload?
My lord, we have given a representation letter, my lord, kindly.
No, why you did not?
22, my lord.
Madam, what is the, why you did not upload till 12.8? Then comes the
We
representation.
did not get this
You
answer letter
withdraw.
at the time, my lord.
You
Responded.
withdraw the petition, approach Mr. Rao, he will do whatever. We can't see if you depend on us, we will go by rules. The rules are binding on the court. This Mr. Rao can do anything. He can admit you even today also.
My lord,
Go there.
it's a covered order, my lord. Covered order is in page number 32, my lord.
No covered order, madam. Each case is different on the facts of the case.
Kindly see page number 33.
2 rounds of counseling are over, madam. In that case, the petitioner.
My lord, respondent number 2 is not allowing the petitioner to permit the
No.
web options.
No, madam. Why have you come after this order was passed on 22nd August 23? Why were you sleeping?
No, my lord, she did not
sleeping,
acquire the
right?
sponsor letter. Though she have made a representation, she did not acquire the sponsor letter, my lord.
Mr. Rao, should we pass a similar order like this or? Huh? All right, similar order. Page 32, certified copy today. No opinion on merits. It must be there. No merits. Like page 32, certified copy today. Yes. Madam, do better. Be more accurate in drafting things, right?
Yes, my lord.
It is same as that of item 4 also.
4. All right.
It's not so, my lord. Here, my lord, the delay occurred, my lord. His grandfather was not well. And second thing, his son-in-law expired, my lord. And third, theft taken place in the locality of 4 to 5 houses.
Where? Which paragraph?
That's what I have not, because that delay, Lordship will proceed tomorrow. I will
No,
find
no,
a better affidavit.
no.
Because, my lord, I was under the view.
The theft doesn't mean that.
Theft is occurred, my lord, in the total locality of 4 to 5 houses. Breakover of flocks.
No. Mr. Theft happened. So this thing, you were declared as non-local candidate when?
After
Do it.
just
Identical order, Mr. We are sorry. We cannot take different view in different cases.
But one word, that father was seriously ill, my lord. First thing. Second, son-in-law passed away, my lord.
When passed away?
There was a death, my lord. Then
No. The petitioner's son-in-law passed away.
petitioner, my lord,
Then-
father, my lord.
Petitioner had to apply. Petitioner had to apply. It has nothing to do with
The
son-in-law.
family, my lord, in the family, the son-in-law passed away. His
Son-in-law had not to apply for being treated as local candidate.
This, my lord, my grandfather was not well, my lord. After that,
Everybody's grandfather, all children's grandfather are not well because they are senior citizens, right?
Lordships,
It cannot be, mister.
lordships are aware in the joint family, my lord, generally
You file an affidavit, the order will be the same.
file tomorrow, better affidavit, my lord. Next week.
Not tomorrow, day after. There's no urgency. When a query was put to learned counsel for the petitioner, no, delete. The petitioner is a candidate who has passed the NEET UG examination, which was held on 7/5/2023. The petitioner was treated as non-local candidate on 2/8/2023. However, by an order passed today in WP number 24378/2023, we have declined the benefit of the common order dated 29/8/2023 passed by this court in WP number 21268/2023 to a student. Full stop. Paragraph in the instant case also, the petitioner has filed this petition only on 1/9. When have you filed the petition?
Yes.
1/9/2023. 1/9/2023. Full stop. Thus, the petitioner is guilty of inaction for nearly period of 1 month. Full stop. At this stage, learned counsel for the petitioner prays for adjournment to enable him to explain the delay caused in filing the petition. List day after. List tomorrow. Tomorrow, Mr. You said tomorrow.
Milord, on 31/8, Milord, your lordships have passed, Milord, a proceeding sheet. What, Milord, enabling me to examine, Milord, whether this particular matter is covered by a judgment rendered by the
No, no,
Rajasthan
no.
High Court.
He was not clear. Mr.
Milord.
One thing, young person, at times we want to tell everybody, not to you. All times you owe a duty to be fair to the court, right? All times.
Milord.
Because we respect you and we treat you as an officer of the court. You have a distinct status. You have been telling us issued the impugned notification on the basis of the
NCT notification, Milord, which has been quashed by the Honorable Supreme Court.
quashed by the Honorable Supreme Court. In this case, the examination was held on 12/6/2022. Already 12/6/2022 examination has already been held.
Yes,
And what has happened to that examination?
that the results have been declared.
Declared.
Yes,
So when have you filed the petition?
Milord, this was filed on 6/6/2022.
6/6/22.
Yes,
And when the results have been declared?
Milord, it's subsequent to this, Milord.
Where?
We filed it.
Date. Mister, you also don't know.
Milord, by that time, Milord, we have filed counter, but it is not.
Result has been declared when? You are the authority, you don't know the
Milord, results, Milord, 27th June 2022. Page 77.
what has happened to this thing. You have failed, right?
No, Milord, this is not a case where we have participated in this. We are the diploma holders. We are aggrieved by the state allowing the bachelors.
Mister, whatever is this process is over. Supposing this notification is quashed, who will be affected?
That the bachelor
No, we are asking you.
holders, Milord. Bachelor degree holders.
Where
We
are
the
they?
diploma holders.
Where are they in the petition?
May I only, Milord?
No, where are they in the
No, Milord,
petition?
not-
Which respondent?
Milord, the bachelors, we don't know, Milord, who are bachelors. Because, Milord, may I?
No means result has been declared, you should
Yes,
find
Milord.
out.
May I-
In
may
the
I please-
absence of aggrieved persons, we cannot grant any relief.
May I only submit this, Milord? The rule has been challenged. Rule, Milord, may have to go because in light of the Honorable Supreme Court judgment, Milord, quashing the NCT, rule may have to go. Milord, so far as the notification is concerned, they may have to take steps, Milord. I would not press on that.
Interim relief, no interim relief can be granted
No,
to you.
Milord, it's a-
We will examine it the ledger.
Heard.
Petition heard on the question of admission.
Now, Milord, I'm sorry.
The petitioner have assailed the validity of the government order dated 23/3/2022 issued by Government of Telangana by which guidelines have been issued for conducting Telangana State Teacher Eligibility Test under Right of Children to Free and Compulsory Education Act 2009. Paragraph. Admittedly in pursuance of the aforesaid notification dated 23/3/2022, the examinations have been held on 12/6/2022 and the result has been declared on 27/6/2022 already. Full stop. The selected candidates are not in full stop. The petitioners filed this writ petition challenging the validity of the rule on 6/6/2022. Full stop. Therefore, at this point of time, especially in the absence of selected candidates before us, no case for grant of interim relief is made out. Accordingly, same is rejected. Petition is admitted for hearing.
Milord, this is not a recruitment notification, Milord. This is a teacher eligibility test.
What interim relief you are seeking?
Milord, my respectful submission is
What interim relief you are
that
seeking?
main relief itself, Milord, is that.
All right.
Milord,
One minute. We will amend it. Correct.
I'm sorry.
Correct. We will amend ourselves. No problem.
I apologize.
Thank you for correction. Has been held, etc. Right? In the absence, delete. Delete absence. The petitioner, by way of an interim order, has sought stay of impugned
judgment.
We will
I
consider.
filed IA, my lord, to explain
Let-
the,
Let IA 1 of 23 be listed for consideration in the first week of October 23.
I'm grateful.
Yes.
But these are respect of Ganesh person, Ganesh ID.
Hmm.
But I have made a counter affidavit on behalf of the TSMC today. But what I was informed in court, not earlier the last year, about 3 lakhs KIDs were.
Who is appearing for petitioner?
And I am appearing for petitioner. In my writ petition, counter is not.
But Thursday, if your lordships have it, for the
That is
reason,
number 12.
for the reason, my lord, till yesterday, my lord, they were busy in distributing their 2-bedroom houses, my lord, for 10,000 people. The GHMC staff.
No.
But that,
When will you file counter, Mr. Day after they decided you will agree.
but day after, no, I'm sorry, my lord, I'm sorry. I only request my lord, to have it day after tomorrow. My lord.
Day after. By that time you will file counter.
One counter is filed, man. Additional affidavit is required to bring it. To
Yes, petitioner in this petitioner. You are an association, right?
Yes, correct.
Petitioner, which is an association of Ganesh idol artisans, seek a direction, no, challenge the inaction on the of the respondents 1 to 5 in not considering the representation dated 18/6/2020-22, seeking permission to sell Ganesh idols made with plaster of Paris prior to COVID 2019. The petitioners in addition seek a permission to sell the same during the ensuing Ganesh Chaturthi celebrations in the year 2020-23. Mr. Harendra Prasad, how many idols you have? You should tell us the number also. So wait.
That's my intention.
That is my writ petition, your lord.
Madam, you should disclose if
Yes.
you had constructed during COVID period.
Yes.
What are you doing? Number of idols apart from validity. This all covered. If you study, you will find the answer. What is it?
Milord, I am
File as
Yes.
number 10, Milord. I am appearing from video conference, Milord.
Yes.
Yes, Milord.
Yes,
Honestly,
Mr. Prasad is seeking time till day after tomorrow, so we are adjourning the case. We are only telling petitioners council, it's all is decided, but they have not studied and they will only argue.
And Milord, the government is not deciding in this matter, Milord, in spite of the Supreme Court direction, Milord.
Yes. You will, day after tomorrow, please appear in person and tell us the guidelines. Mr. Harendra Prasad, learned senior counsel, whatever. It's attached to so and so. Praise for short accommodation to enable him to file a counter.
I have filed a counter additional affidavit. I request.
Additional affidavit. List on. You find the answer, Mr. We already have the answer. Today also we can dictate the order. These people are not ready. They will.
I informed this court, my lord, that we had provided 3 lakh clay idols last year. I wanted to place the figure before my lord for this year to avoid
This is all
idols.
plaster of Paris, all for this thing, environmental pollution. This all
We
can
have
be
created 25 basis
List
points
on.
for it.
list on tomorrow. What?
Day after.
Tomorrow, Milord, because already the POP ideals are being.
No, Mr. We don't have any problem. The thing is, he is paying for day after is what, 6th?
Yes.
No, Mr. It can't be 6th.
So far as
Friday.
No, it can't be, Mr. 6th. We already have 102 cases. It can be either 5th or 8th, whatever choose.
8.
8th, Mr. 8th we will decide. 8th we will decide, Mr. We are ready today also. After family order in this case, also we are ready. 8th December. 8th, September.
I'm deeply obliged for my.
Item 11, 12.
Day after.
All right, same order.
second
Where is that, madam? Next file.
guidelines are under chart.
1 minute. We know that. See, Mr. You should better study. Have you studied it? It's issued by Central Pollution Control Board. It may have been examined somewhere. Challenging saying that it is violative of Article 1421 is fine, right? But you have to substantiate this. Anybody can say violative Article 14, this thing, 19, 21. In this writ petition, next case, 12. Petitioner has assailed the validity of the revised guidelines issued by Central Pollution Control Board for immersion of idol, totally banning plaster of Paris idols. Full stop. Mr. Prasad, what do you want? Additional affidavit? Counter. Mr. Prasad, Arinder Prasad, what? Praise for short accommodation to enable him to file a counter in this writ petition. List on whatever, 8th of September 20.
I'm deeply obliged. And no further time will be granted, Miller.
No further time we will be granted and we will decide it. You are the petitioner.
No, I will
No,
repeat
he is a
petition.
third party. He is an intervener.
Intervener. So these people should be ready. We will decide it on 8th. Forget Mr. Prasad. Once indulgence has been shown to him, if he is not ready, you are on a question of law. Argue. How Article 14, 19, 21 substantiate your submissions. Legal issue. Yes.
Madam, for the respondent
On the question of admission, petition is admitted, record peruse petition is admitted for hearing, counter if any be filed within 6 weeks. Six weeks further time, you say, further time. Same order. Petition is admitted for hearing. Interim order granted on 3/8/23 shall continue. 6 weeks further time is granted to file counter. Counter 6 weeks time. Interim order is already there. Yes. 6 weeks we have granted. That's why senior counsel. No. There is already an interim order in your favor, right? So we have said interim order shall continue. Yes. Mr. Please appreciate that today have you seen the final hearing list? Which case is the oldest one? 98. We can't hear even if they file return tomorrow. We can't hear it day after. Fine. There is an interim order. Nothing happens. Everything is subject to the result of the petition. Yes. Yes. So two questions, Mr. You are respondent, right?
Yes, ma'am.
Whether petitioner was heard, which provision empowers Lokayuk to stop construction? Act, Lokayuk Act.
There is no act.
So
in this case, my lordship, there is a conflict between it.
You don't have any power. Well, order. You have the power. You are municipal corporation, right? Who are you?
Lokayukta, my lordship.
Lokayuk. Then who appears for municipal corporation? Nobody. Then
Surendra Reddy is the municipal corporation.
Not appearing.
I am appearing for respond number 2, my lord. In this case, my lordship.
No, corporation.
Corporation Surendra Reddy.
Huh?
Mr. Surendra Reddy.
Not appearing, right? Fine. Under which provision you have power to stop construction? And how it can be allowed to be fettered by a direction issued by somebody else who has no power? You have your independent power. You means Mr. Reddy.
Yes, madam. Corporation. Warangal
Corporation. Yes. Mark the presence.
Both is fine.
You are a corporation, Mr. Reddy. So how Lokayuk has jurisdiction to stop construction? No, if he commits, he holds a public office and guilty of misuse, and then you approach against him to Lokayuk.
My lordship.
No, this order has to be quashed because it is from the dictates of somebody else who has no authority in law. You, Mr. You will be at liberty to approach this
sir.
Greater Warangal Municipal Corporation, not Lokayukt.
Yes, I have already approached. I filed a representation. Last week, kindly direct for dispose of.
In this writ petition, mark the presence with consent of the parties, same is heard finally. In this writ petition, comma, the petitioner inter alia has assailed the validity of the orders dated 28/12/2022 passed by Lokayukt State of Telangana and order dated 31/3/2023 passed by Greater Warangal Municipal Corporation, by which the appellant has been asked to stop further constructions until further orders of Lokayukt. Paragraph. Admittedly, the Lokayukt under the provisions of it is considered by admittedly under the provisions of Lokayukt Act, right? Which year? Lokayukt Act, which year? Find out, madam. They don't know. Lokayukt Act 1983, Lokayukt has no power to entertain a grievance with regard to construction, full stop. Therefore, full stop. The aforesaid legal position has not been contested by learned counsel, who appears for Lokayukt as well. Paragraph. Therefore, it is evident that the Lokayukt had no authority to issue the impugned order dated 28/12/2022, and consequently the Greater Warangal Municipal Corporation had no authority to issue the impugned communication dated 27/3/2023 based on the directions of the Lokayukt. Paragraph. For the aforementioned reasons,
The earlier order, last time, give representation, I have given representation.
we have said that it shall be at liberty. It is not a petition filed by you for in his petition. We cannot grant relief to you by directing. Nothing.
Time may be fixed, that's my own request.
It will be looked into by them. Same order.
Same
Same order.
28/12/2022
and this thing Lokayukt 28/12/2022 and Greater Warangal 31/3 allowed. Same order. Yes.
May I please?
Yes.
I beg to represent Sagarika.
Non-speaking. Mr. Rao. Yes, we know non-speaking order.
That's my kindly see, my lord. That's my kindly see the order passed by the University is page 15, lord.
Page
15, lord.
1. Hey, we thought that you will tell us that we will pass a fresh order.
I'll pass it.
Right.
The same order I have to pass because the GO.
No. Speaking order. Grievance of senior counsel was confined to only non-speaking order. He will pass a fresh order.
I'll have to come back, my lords.
We don't know. So then we have to examine this then. give them, because
I have to,
see,
my lord, I'm saying.
first, we are telling, 1st of September, we only recorded this contention. So therefore, he is,
No,
we,
last
if
time,
it has
not
to be heard.
last
You are
time.
saying that you are right in saying that you will have to come back. But thing is that then in that case, he has to be granted the faculty to file counter.
My lords, I'll tell you lordships what's happening. I'm just taking liberty, my lords, because I see a few more matters happening. Unfortunately, today what's happening, my lords, while the citizens' grievance is being microscopically examined, state action is getting a lot of laxity. This is unfortunate. After all, it's too late in the day for me to come and tell your lordships. 226 is for supervision of state action. What's happened, my lords, for example, in this matter, when your lordships passed it,
No, you are talking about the orders passed by this court.
generally,
Yeah.
not your lordships. I'd be too
Because that
unwise,
is, we can't,
to say that.
we can't do anything about it. You have the remedy under Article 136 if we pass that.
Unwise to say that. I'd be too unwise to say. All that I'm saying is this. Look,
Obviously, the only thing is what we are telling is last date of hearing in your presence, this order has been passed. That the only, this thing is a non-speaking order. Probably that's why, but you are saying that if it is quashed, then on this ground you will have to come back again. You are justified in saying so. But only thing is, then we have to give them some breathing time to file counter. Because if we allow your writ petition today, the order won't stand because you will not be possible to, it will not be possible for you to defend.
36 is not any difficult.
No, defend it in saying that the court has not granted any opportunity to us to.
Only
If you
problem,
would have been for respondent, I think in Mr. Rao's position, you would have said that, sir, I need time to
it's not
file
a
counter.
question I envy, my lords, but
No.
my lords, only sensitivity I'd like to bring on
My friend, last may kindly, I just, last may kindly say the university, similar cases are coming and coming. University addressed a letter to the government seeking exemption of the rule for giving a notification. There is a rule press registration after the cutoff date. Rule 126, last may kindly say, page 126.
No, but you want to file counter or you want to, he is ready.
File my counter.
Right away.
My friend also not, there is no need to make an argument. The university addressed letter to the government seeking permission for giving a notification, calling applications.
Who is appearing for comment? Nobody.
I believe the respond number 1.
What have you, he has written something, we don't know. So, yes, Mr.
my lords, I think this is a very sensitive input.
Yeah.
We'll now require a response from the government.
That's why we are granting them
It's a
time.
sleeping elephant that
But 2 weeks time, meanwhile, most probably notification will come, he may not apply. But even on the delay ground also, it also be dismissed for the simple reason, because the notification was issued on 3/8, ended with the 12/8.
No, they were in first round of litigation, they were here.
Yes, they were. In any event, they are now bound by your
Page
lordships earlier on.
36, no. Page 36, earlier round of litigation, he was there. Then 19/8 an order was passed, then he has come again. He doesn't want to come again now.
But
Right.
But 2 weeks time, I will enter, file my counter. They
Do
can
we have
counter
that much of time in hand? We don't
for
have
1 week, 1 week.
1 week. Huh? Mr. Heard, Mr. L. Ravichandar, learned senior counsel for the petitioner with so and so. Mr. This thing, you also don't want to respond.
Please respond number 1. I will ask to get in.
He submits that he doesn't want respondent number 1 accepts notice. Mr. Prabhakar Rao, 2 and 3, praise for and is granted a week's time to enable him to file counter. List on. One week, next Monday.
Next.
12 September 2023.
Sorry, my lords, if I had taken too many liberties.
No, we thought that probably you are saying in the context of orders passed by this court.
No.
Then
Not at all.
we can't help it, yes. You have a right to criticize, fairly criticize, but we can't help it sitting here.
It was not the intent.
Yes.
Item of the
Mr. Prabhakar, finally, what victims today?
Pursuant to my Lord's order on 17th of August, my lord,
Ah,
I have filed an affidavit, my lord, bringing to my Lord's notice
ah.
the statement which I had made before my Lord's, my lord, I have filed it in form of affidavit to bring it to my Lord's notice, my lord, the action taken by the state. But
Chart.
in paying the
Chart is there, madam. Ah,
earlier, I had informed the court that 20.
Rahul. Lockler, Rahul Reddy. Hey, madam, Rahul Reddy, Lockler. Call him. Hey, no, not here. Lockler. You are looking in the list. Mr. V.S. Prasad.
23 families were paid the ex gratia. Subsequently, what 24 more families have been paid. Ex gratia amount of 4 lakhs.
1 minute. So, Mr.
23rd August, I
no, Mr. Prasad, what had happened? 1st August, we had issued certain directions.
Yes.
11th August and 17th of August.
17th of August, my lords were pleased to record my statement. I have requested my lord that I will place it in a place.
All right. Don't call.
I will place it by way of an affidavit.
Not needed. Yes.
I have placed it by way of an affidavit bringing to my lord's notice. 24 of
No, we will ask you. One by one, you please answer. It will be very easy.
My lords.
Because what we have done is we have compiled the directions and your this thing and petitioner submission, right? That's what. So 1 minute. Mr. It is not an adversarial litigation, right? That's why we are asking. They are willing to comply, and we will ensure that they comply.
There have been complied many directions of this.
1 minute. So therefore, we have to pass an order. We have to handle the way this thing. No, who will write? You can this thing. So, first direction on 1st of August, Mr. Prasad, was number of deaths in Jaishankar, Bhupalpalli district.
Yes.
So, how many deaths?
There were 4 deaths, my lord. 4 deaths.
Five.
My lord,
Five.
But 4 they could identify, my lord. 1 was missing. Subsequently, what has happened, my lord? Then the
1 minute. So, 1 is still missing.
present affidavit, if your lordship sees, present affidavit filed on 20.
No, you tell us. We will not see anything.
I will do this.
You are here, Mr.
One is missing, my lord.
Very few cases we can take the liberty of not referring to record.
But
And when senior advocates appear, we want that to happen, that we should not be, we rely on you. It's not again and again we are telling not an adversarial sort of litigation.
That's the reason.
So what? Bhupalpalli, this district, 5 deaths took place, 4 identified, 1 is still yet to be identified.
Yet to be identified is.
Arey, Mr. Who is this person standing there?
Mahalakshmi. In the present affidavit, I have said so. Lady by Srimati Gattam Mahalakshmi of Jaishankar Bhupalpalli is missing due to the heavy flood. The search operation made with all such resources.
She is what her name is?
Gattam Mahalakshmi.
Missing.
Yes.
All right.
With regards to the
You will find out.
Yes.
You will carry on the efforts to find out.
With regards to one job.
So, total this thing, how many flood victims are there? You told us 41. Correct?
47 months.
No, sorry, not flood victims. Total number of deaths, you told us 41.
Yes.
Correct? Mr.
Yes. 47 months.
47.
47.
Actually, I claimed 51, my lord. They are showing that 49. Out of that,
I'll explain.
1 minute.
I'll explain. 47. 23 I had informed my lords that 23
what is your figure? 47.
47
have lost their lives.
Yes.
Then out of, you told us 23 identified benefit given.
24 also have been given.
24
also families are also
all given.
Yes, 47 have given. One more person, my lord.
All persons given the benefit.
Yes.
Correct.
This is the
position latest.
Yes.
Acha, then we had asked you, how many cattles? 813, according to you.
Pardon me.
813 cattle lost their life on account of floods. That's what you had told us,
Yes.
Mr. Prabhakar.
Mr. Prabhakar.
813.
Yes.
Regard to
No, no, you are a stand, Mister. We have gone through it. Your stand is 813. Right? You will find it out, Mr.
I'll
Prasad.
find.
So then,
I've also informed the court, my lord.
yes.
One person who died, in addition to that, was paid Raitu Bima. Raitu Bima is insurance which was created by the state in favor of the persons who die, my lord, or during the floods.
So all persons insurance given? No.
Only one person was given, my lord. That is additional amount of 1 lakh given to a person. Addition to the benefit which is already given, ex gratia of 4 lakhs. Other aspect is, my lord, with regard to the medical facilities which were made available to the persons who are affected, families affected, my lord, duly medicines have been also given to them. Medical facilities have also been given. But now, my lord, all the health relief camps, my lord.
1 minute. Flood victims, you have given medical relief.
Necessary food, stay and medical support.
Medical relief, food,
Stay. But in fresh water.
So how long they will continue to be?
I am informed through this authority, respondent number 5. There are no relief camps now being continued. No relief camps being continued.
No relief camps.
But what I would request.
So what you are trying to tell us that relief to all flood victims where when they needed,
Yes, ma'am.
it has been extended. They were made to stay in flood relief camps, and now nobody is there in flood relief camps.
192
They have returned to their homes.
Yes, 192 relief camps, 20,387 people affected by floods. 192 relief camps, 20,387 people were affected by the floods.
And they were staying in flood relief camps. All of them have gone back to their villages.
Back to their home.
Okay. Then, Acha, you have set up weather stations.
The weather station, I've also given this.
Weather stations.
Yes.
Telangana State Development Planning Society to monitor weather data and hourly information to state data and to promptly take all precautionary steps.
Yes, bro. This is also done.
Done.
Yes. But
it is set up already.
It's set up. But if your lordships kindly see it, if your lordship go to C, D and E, C, D and E, the same page, the Chief Secretary of the Head of State has conducted regular teleconferences during the period and video conferences with the district collectors, alerting them regarding the rains forecast and briefing them regarding the measures to be taken. Subsequent day to state has provided 10 NDRF teams deployed to helicopters in critical locations for the purpose of rescue and relocation. Thereafter, along with the IAF, Central Forces, NDRF, the local police and the state fire and emergency departments are deployed in vulnerable locations for rescue and relief. Holidays were also declared by the school to safeguard the. We have set up 192 camps for 20,387 victims. But I have also said so that Gaddam Mahalakshmi is missing, and the other person who was referred to by my friend is already been paid.
Right. We have taken note of the measures. Now, Mr. Prabhakar, what do you say?
Yes, my lord. Maximum they have been complied, my lord. Earlier,
What else is required to be done? You tell us.
last occasion, this honorable court directed me to what else to be taken place.
That's what we are asking. What else should they should
Kadakarkar stated in my reply, my lord, at page 7.
forget? No, page 7. You tell us what do you want.
Yes, my lord. They need to prepare the plans, my lord, according to the Disaster Management Act. If they have been prepared,
What is section 39 of this thing, Disaster Management Act?
section
Mr. Prasad, section 39,
section 39.
Disaster Management Act.
Yes, section 30. Your lordship may kind see.
My first of the affidavit, I had requested that the state would be taking all these measures, requesting time till 2024 March. But I had requested my first of the affidavits filed before my lords, appearing saying that everything will be put in place by March 2024.
To prevent the disaster, to manage the disaster and to provide the relief.
They have to do it.
Enacted the act, my lord.
We have agreed this.
Yes.
We have agreed to your submission
Yes,
that they need
and
to
the
take measure.
same were upheld by an apex court in Swaraj Abhiyan case.
They are not challenging
Yes, yes.
section 39. You are saying we will comply.
Yes.
It's time to be given that we will decide. Actually, Mr. Not till March 24, that means April 24, you will tell us. You see, you take action and submit a compliance report, we'll say by December.
Fine.
Yes.
Fine. Deeply open.
And, yes, what else, Mr.?
I have stated 8 suggestions before this honorable court for kind consideration of this honorable court to direct the government to protect the right to life of public at large and property of the public at large. It is 7 I have.
So, Mr. Prabhakar, what now the floods are not there in the state, right?
No, Lord.
1 minute, listen. Now, on a long time, our object is on a long time as a long term measure. We have to ensure implementation of measures under 39.
Yes.
So what we will do is grant them some breathing time of 2.5 months and fix a date in the month of December before vacation and find out from them what section 39 measures have been taken.
Yes.
Correct?
Yes.
Mark the presence.
One more, my humble submission, finally, Millard. The project which is Kaleshwaram constructed under Godavari, Millard, 3 dams are there, Millard. I categorically stated in my reply at page 8, Millard, under 9 also, Millard. Those 3 dams, Millard, they are filling up the water. Once the flood would come, immediately they are releasing the water.
Which dam?
Kaleshwaram, Millard, at page 9, item number 5. Yes.
This is by way of yes, passed on the suggestions which he is making to the state, but to take appropriate measures.
What is the measure he wants to take?
I have put it across to the state. This is being too technical for me. I have put it across to the state.
Right. Measures to be taken, he has put it across.
Yes.
They need time to respond.
Yes.
We'll grant them. Next date we will, this thing, ask them what all have done. And about 39, about this dam.
Yes,
right.
And page 8, Millard, Himayat Sagar, Usman Sagar, which is existed a west side of the Hyderabad city, and they are not being properly implemented. GOMS number 111 of 1996, which was approved by an apex court, so that Hyderabad is being submerged in many areas, Millard. At page 8, I have categorically stated it, item number 3.
Completely a different issue, Millard, which is pending before this. Completely a different.
Mr. One by Mr. Prabhakar, earlier also we had told you we should take the issues which are interconnected. This petition will not be disposed of in December. We will take it up. First is commonality of issues. What relief is 39 and this dam, because it may cause floods again.
Yes.
So we will put them, give them some time. Say 10 weeks and ask them to come up with this.
Deeply obliged.
I'm obliged.
Yes. Mark the presence, Mr. Prabhakar, Mr. Prasad. This quote, 1 minute. What is the order? 70. No, first one is in this petition, comma, one is Mark, the state had witnessed continuous heavy rainfall in and around Godavari river, causing floods in low-lying areas, which also resulted in breach of irrigation tanks, severe damages to agricultural crops and roads, and loss of how many lives? Loss of 37 lives.
May I start?
47 lives in the month of between. The rain was between when? Between
19th and
19th July to August 15th.
19 July to,
August 15th.
no, that was second, no.
19th and 20th, 19th and 20th of.
No, my lord, 19th July to August 5th, my lord, in my.
19 July till 27 July 2023.
Yes.
And thereafter in the month of August as well.
Yes.
August as paragraph. This court, a bench of, this court had issued several directions to the state on 1/8/2023, 11/8/2023 and 17/8/2023. Full stop. In pursuance of the aforesaid interim orders, the compliance report has been filed on behalf of the state government. Full stop. The petitioners have also submitted their suggestions which may be implemented by the state government to ensure the safety of public in general in case any flood situation is caused in case any flood situation reoccurs due to heavy rains. So stop. Paragraph. We have heard learned counsel for the parties and have perused the record. Full stop. The from perusal of the perusal of various compliance report, it is it can be gathered that 192 flood relief camps were set up by the state government, in which 20,387 flood victims were granted the relief, granted the medical relief, and were provided food and fresh water. Full stop. The full stop. All the flood victims have now returned to their villages, and no flood relief camps note of, and he doesn't need every time this court's direction.
hopeless, deeply hopeless.
Mr. Dam also, you find out what can be done.
Yes. In fact, I have forwarded made by request by the petitioner to the state. I'll come back with the report on December 18th.
See, on his own he is submitting. No step. Give one step. What a coincidence, right? You hope this has step.
Deeply hopeless.
No. This, he submitted section 39, Mr. Prabhakar, and then say, Mr. Prabhakar fairly submitted that most of the directions issued by this court have been complied with by the respondents.
I'm deeply hopeless.
However, he submits that section 39.
Yes.
Right? You put the pins. All right. Yes.
Deeply hopeless.
That's how public interest litigation should be, right?
Yes.
A constructive sort of an
Yes.
approach.
I ever grateful to your lordships. I ever grateful to your lordships.
No, this thing. We are doing our duty. But this is what, it is how public interest litigation should be argued, Mr.
Yes.
Prabhakar. That's what we are saying.
Yes.
We appreciate your suggestion also.
I'm deeply hopeless.
The otherwise adversarial sort of things.
Yes.
Every day we come across the encroachment on government land, people start arguing like as if it belongs to them. Yes. Okay. Yes, Mr. Advocate General.
My lord, sir. 19, item 19.
My
lord, the cause of the death is, my lord.
19 and 20, in 20 you have to file counter. We shall take it up both the cases together.
Yes, my lord. Yes.
20 they should file counter, right? Already in 19 they have produced the reports, etc. But 20 is a petition by to constitute a sit and take compensation of 50 lakhs.
So file it.
You have please file a counter.
Yes, my lord.
Item number 20, Learned Advocate General, praise fund is granted 4 weeks time to enable him to file counter. Petition is admitted for hearing, right? List along with 19.
Yes.
Yes.
May I please? My lord, the issue involved is about the legal issue, my lord. Synopsis, my lord.
Yes, we are ready. So, Mr. Now, no, correct. But we are asking you, now it says stand, right? That there is an arbitration clause. Remedy of a civil suit would be very tedious, right? You know how much time it will take, and first appeal, and then whatever happens, we don't know. So I'm just, before deciding this, we are putting it to you. So don't you think without contesting the case on merits, arbitration in the change scenario would be a better option for you? We will, if we ask you, if you want to really contest, we will enter into and decide. But don't you think that it's a better option now, and the change in stand has been necessitated on account of change in law?
If the intention of the advertisement in the party is to ensure the litigation,
Yes.
the outcome of it.
Yes.
We have taken up in 2016. In 2016, whether the advertised tribunal was concluded.
No, we can record a his undertaking that he will cooperate and will not seek any unnecessary adjournment in the proceeding before arbitrator.
Yes.
But provided this is by way of a suggestion, then if you want to write it out, then we will have to decide. I think without contesting, it's a better option. That we record his undertaking also, that he will not seek any unnecessary adjournment, will cooperate with the early decision of the proceeding. Arbitral tribunal should be constituted. He will give consent for this thing.
For such a conceding method, I have to take instructions from my.
No, but. So would you like to seek instruction or contest?
I'll take instruction method. I mean, if your lordship kindly considers.
Where,
Because as on today, my lord, we are contesting it.
Ah.
Since your lordship has appealed.
just think about it. It may like,
I paid, my lord, I mean, court fees, I paid the suits in the 2020, my lord, nearly 6 lakh rupees court fees are just paid.
but it will be refunded, no? Now, you will withdraw, then it will be refunded now.
And one more thing,
The only thing is court doesn't give interest, that's all.
My lord, your lordship suggestion is, my lord, this variance because within 1 year, even as per the act, also within 1 year, the act will be over. The suit,
No, but you will,
the suit will take years, my lord. In fact, it will be better.
Even now, the suits are pending before the commercial court, where my lord, the time period is fixed for the disposal of the suits also. They are now pending before commercial court.
so you think, if you want to argue, we will go ahead.
Since your lordship made a suggestion, my lord, I mean, we have to consider, I have to seek my instructions of my client. I can't readily say, my
How
lord,
much time?
maybe within 2 or 3 days, my lord, I can report back to your lordship.
6 is, we already have 102, that can't happen. 8th, we can take it up.
Sir, 8, 11, my lord. 8,
11th,
Monday.
Monday.
Next Monday, my lord. Yes.
Monday 11th. Mark the presence. In this petition, comma, in this appeal filed under section 37 of the Arbitration and Conciliation Act, comma, petitioner has assailed the validity of the order dated 2/6/2023 passed by the commercial court, by which petition filed by the appellant under section 8 has been rejected. Paragraph. The parties had entered into a registered paragraph. Facts giving rise to filing of this appeal briefly stated are that the parties had entered into a registered development agreement cum general power of attorney on 23/3/2006 full stop clause 25 of the aforesaid registered development agreement cum power of attorney provides that the dispute between the parties have to be referred to a panel of 3 arbitrators. Out of the aforesaid 3 arbitrators, one each has to be appointed by one party, and the umpire is required to be appointed by remaining 2 arbitrators. Paragraph. The plaintiff invoked the arbitration, plaintiff stroke respondent invoked the arbitration clause, and a dispute was referred to a panel of 3 arbitrators. The full stop in view of the then prevalent position, legal position as enunciated in so and so versus so and so 2005 within bracket 6 ALD, right? ALD
2015, my lord.
15 6 ALD 584 comma 584 comma that dispute regarding cancellation of registered documents are not maintainable, comma, the plaintiff stroke respondent withdrew the arbitration proceeding and filed a there full stop. Thereafter, the petitioner filed a suit for cancellation of this thing, DAGPA, whatever, DAGPA, full stop. The defendant number 1 thereupon filed an objection under section 11 within bracket under section 8 on the ground that the agreement executed between the parties, this whatever agreement executed between the parties dated 23/3/2016 contains an arbitration clause in view of later decision of Supreme Court in dash versus dash 2021 volume 4 SCC 786. Paragraph. Paragraph. The commercial court by an order dated so and so 2/6/2013
Interim order needs to be extended.
Interim order shall continue. Then say list on 12th September 21, 22, 23.
Public.
So previous, my lord, this matter, also filed, my lord, and appellate, and grant 2 weeks time, my lord.
What? Vacate stay petition.
Yes, my lord. I'll make it step.
That's why senior counsel is smiling.
Yes, ma'am.
So conveniently you are saying.
Earlier in this matter, my lord, additional original appeared, my lord. Now the informed department.
You have filed vacate petition.
I filed.
You have filed.
I filed, okay.
Then his petition, right?
Yes, sorry.
What do you say, senior counsel? 2 weeks for what we don't know. What happened? This thing proceedings are before under the act have been concluded. This thing final stage.
No, not concluded, my lord. They wanted to appoint a surveyor, my lord, to survey the property.
No, interim order granted by this court says that you continue with the proceeding, but final order shall not be passed. That's why we are just trying to ascertain the reasonableness of the prayer for adjournment with reference to each stage of the
They
proceeding.
wanted to conduct the survey, my lord, till that it has not happened, my lord.
Alright, so we can grant them time.
2 weeks.
But argue on the next date of hearing. Senior counsel has today didn't say anything, but next day he will oppose, right? Mark the presence.
Deeply.
This court by an interim order dated, a bench of this court by an interim order dated 14/7/2022 and directed that the proceeding under the Public Premises Eviction of Unauthorized Occupants Act 1971 may continue, but final order shall not be passed. Full stop. The respondents have filed an application seeking vacation of the interim order. However, learned counsel for the petitioner prays for adjournment to enable him to prepare the case and argue the same. List on 18th September 23
Yes.
for consideration of IA so and so seeking vacation.
Deeply obliged.
He wants to complete through interim orders of this court. Now comes the permission to attend classes.
The classes start.
That was granted, my lords. Classes are big.
So what IA you have now? It has.
IA2 is also been allowed. Not
Yes,
So
it has
what
been
is
allowed.
1 of 23? No orders necessary to be passed on 1 of 23.
1 of 23.
What is 1 of 23?
No orders are necessary, my lord. To appear for the examination, that has also done.
All right.
He's also attending.
He is the petitioner, right?
Yes.
Advise him to attend classes.
Yes.
And not to spend time here in the courts.
The classes haven't begun, my lord. Like I asked him even today.
Well, I mean, advise him to be in the library, read all the classic case laws of. I think you will inspire him to do something better than not attending classes and this thing.
Definitely. In fact, I've been literally parenting him on that.
Yeah.
Telling him you have better go back to college. Yes, starting next week.
Mark the presence. Learned senior counsel submits that IA 1 of 23 has already been allowed. Therefore, no orders are required to be passed on IA 1 of 23.
Right.
What amendment?
To represent. Lords have filed amendment petition.
Yes, what do you think, Mr.
My lord,
Can we allow amendment?
minute can be closed, my lord, because the my lord, the repetition can be closed, my lord. The section 243, the last occasion, my lord, please go ahead to get instructions. The 243 repeal of certain enactments of savings. Now, my lord, this repealing is not yet notified. But you can avail the remedy under 243, my lord, and after leaving a law,
Why he can avail of the remedy?
no, personal insolvency.
Madam, IA, my notes, please give. I can't see. Yes. Say, the grievance is that section 94 is not notified of the IBC.
Yes, yes.
So he cannot get a declaration that I am insolvent. This is number one.
Yes.
Secondly, he says that he had filed a petition under Provincial Insolvency Act. It was rejected by an order dated 8/12/21.
Yes.
So he is remediless and therefore under Article 226 and interim order.
Therefore, the repeal, section, the very itself, it is not notified. Therefore, we can avail in our old act. The
No. But the problem is, Mr. Praveen Kumar,
my lord.
is he had filed the petition under provincial insolvency.
Yes.
It has been rejected by an order dated 8/12/21. Where is it, Mr. 8?
Page 41, my lords.
41.
Neat copy is at page 41A.
8/12/21, right?
Yes, my lords.
Page
41A.
41A.
Yes, my lords. 41 is the title.
Returned for. Who has returned?
The small causes court section, my lords, on the ground that how IP is maintainable under.
Page 26, main case.
We will, Mr. Order, we'll set aside this order.
One submission, my lords. I have prepared the notes. One submission I will make.
No. Mr. We are granting relief and you are making
Yes, yes, my lords.
this order we will set aside and we ask the this thing small causes court to try your petition
Yes,
on
sir.
merits.
Yes.
There are two learned single judge judgment of this honorable court. If your lordship so says, my lords, I will pass on that. Because that has to go.
Watching. What orders, single judge?
I may be permitted to pass on, my lords. I have prepared small notes also if your lordship so previous notes.
Oh, nice. No, but why it has been written, what has been held?
They say that under section 8, because section 8 of the Provisional Insolvency Act bars petition against banks, companies and corporations. That is the view of some other high courts also, my lord. But Kerala High Court, my lords, has said no, section 8 doesn't bar it because, my lordship, if your lordship sees section 8, there is ambiguity in the main provision.
Mr. He doesn't want closure of the petition. He wants to continue perpetuity because interim order is granted. He wants it should come up after 25 years. By that time, petitioner would have left the world. He will be designated senior counsel. Then lighter when we are saying, Mr. Don't take everything seriously, right?
I cannot take.
Cannot take. Good not to take things serious. So, what is the reasoning of the decision of single benches you are saying?
My lord, they,
Of our court is the reasoning.
Yes,
Which page?
Page number, my lords, of this honorable court.
You have High Court of Allahabad, you have.
Yes,
I
that
think
different high courts. Page number 10 is our high court. Page number 13 is our high court.
10. So, it should be annexed in the compilation first, right? Allahabad judgment, nothing single bench.
Yes, my lords.
What is it?
Page number 10, my lords.
1 minute, one.
So,
You have filed against whom?
my lords,
You have filed the petition against whom?
against the banks.
Then section 8 prohibits filing of such a petition against bank.
It is what the learned single judge say, my lord.
No, what does section 8 say?
says against corporations, association or company registered under any enactment.
So it's not either of these. Bank is a separate entity.
One submission. Company registered under any law, banks, all banks under Banking Regulation Act of 1949 come under the company registered under any law.
So you are saying that no remedy.
Yes, that is what page number 13, my lords, another single judge of this honorable court has categorically in point of the banks have said. Page number 13, para level.
Case of bank.
Case of banking, page number
So
30.
then this should have been the first decision in your compilation.
I'm sorry, my lords.
This applies directly to your case, right?
Yes, my lords.
It should be first in compilation. Page 11. Yes, Mr. It requires consideration. Madam. We'll admit it.
Yes, my lords.
You are already surviving on an interim order, right? Be happy.
Yes.
It's for admission.
Yes, my lords.
Heard on the question of admission. Good effort put in.
Oblige, my lords.
So that's how you should do it. Where is that this thing?
I have given notes.
Note? We don't have any note. Synopsis.
Yes, my lords.
Good. Keep it up, Mr. Young Khan. Yes. The petitioner heard on the question of admission. The petitioner had availed of loan from respondents 4 to 17 to the tune of rupees 3.25 crores. Full stop. It is the case of the petitioner that on account of circumstances beyond his control, amendment allowed.
Yes, ma.
Heard on beginning right. Heard on IA 2 of 23, taking into account the nature of proposed amendment, same is allowed. Let amended petition be filed within.
We have filed, my lords. After filing only number comes.
All right. Allowed.
Oblige, my lords.
Petition is admitted for hearing counter if any be filed within 6 weeks. Next.
Your Lordship, item 28 and 29, Your Lordship, are questioning the GOM.
Admitted for hearing. 6 weeks time is
Batch is pending.
6 weeks.
Batch is pending, Your Lordship.
6 weeks time is for granted to file counter list along with WP number.
T50 double 507.
WP
WP double 3507 and 2022. This batch is there.
Madam, right? Yes. Yes. Yes.
What's your
32, madam, 54. 32, 54. Yes. Counter is not filed.
Counter is not filed by the state, madam. State has to file the counter because rule is.
Petition is admitted for hearing.
My lord, in this case,
Let
my lord,
counter if any.
in this case, my lord, in one of the case, my lord, I filed the counter. In all cases, he similarly situated, my lord, where
Memo has to be filed or copy has to be given. Which case you have filed counter? Mr. Item number 32.
54, madam.
54.
All cases. My lord, I will
Which
file
case?
copy, sir.
1 minute. Which case you have filed counter?
In Aravindo Pharma, I filed, my lord, I know.
No, we don't know Arvindo Pharma number, serial number.
Item 34. 34, madam.
34.
My lord, in WP 22739 of 22, I filed the counter.
My madam.
No, this is not
32.
WP 27. Which case?
32, my lord, item 32.
Municipality, others.
22739.
Yes, my lord. This is
All right.
related to Aravindo Pharma.
Municipality seems to have filed counter, madam. This matter, not the government.
He is government, right?
Administration I filed.
Very good.
Because municipal administration.
State counter, they can pass on to all the other case also.
Item 30 to 54, madam.
Fact, madam, we have included in documents, madam. Those documents are not shown on only the copy of the copies. Refer to certain circulars, madam.
Speak into the mic so that your friend can hear. He is not heard.
My lord, certain circulars which have been referred in the counter, my lord, those were not served upon me. Only the counter
Item
copies, sir.
30 to 54. You are government advocate. What? Government pleader?
I will file counter. I will, GP for municipal administration.
GP for municipal administration submits that he has filed counter in WP number 22739 bar 2022. Learned on the learned counsel for the petitioner submits that learned counsel for petitioner in WP number 22739 bar 2022 submits that he has not received the copy of annexures, copy of documents annexed with the counter. Paragraph in view of aforesaid submission, learned GP undertakes to supply a copy to Mr. Counsel for petitioner in WP number aforesaid rate petition, right? the land held by the petitioner Say, 1 minute. His submission, learned senior counsel for the petitioner. Just now. It is further submitted, one line. It is further submitted that claim of the petitioners except the petitioners to whom the compensation has already been paid be examined within a fixed time limit by the competent authority. They will not go, Mr. They, on the other hand, then what he submitted shall be examined. Examined. Such of the petitioner's grievance, madam, read what is his submission. No, you don't, claims of the petitioners, claim of such petitioners to whom the benefit of compensation, delete everything, to whom the benefit of compensation has not been extended, shall be examined by the RDO Siddipet within a period of 2 months from today, and the amount due to them shall be paid to them. Paragraph. We have considered the rival submissions made on both sides. Para 8 of the will find out. If we don't find out, then you are just getting, give it. Other, we have 340, we have other memo you do. Read as under quote. Paragraph. In view of the, no, not this memos. Therefore, it is, therefore, in view of consensus, right, in view of consensus arrived at between the parties, and in view of the fact that the petitioners have confined their grievance to paras 8 of the memo, memo dated 4/7/2023, filed in all the 3 writ petitions, it is directed that the Revenue Development Officer Siddipet shall consider the claims of the petitioners, within a period of 2 months from today by a speaking order. Needless to state that the
Obliged. Much good.
Oh, lunch motion. Huh. We have given a dictation in the morning. Who has taken in item number 4? Whether she has typed, give the order. Lunch motion.
Your lordship's common order is there.
Common order?
Your lordship's order pertaining to CCAT.
29th August. Which common order?
Yes, ma'am. Yes, ma'am.
Not 29th August.
No.
Representation.
Huh?
Consider representation for registration of under B and C category.
You are ready to consider or what?
Lordship kindly see, he did not register himself. Pursuant to notification issued by the university.
Why you did not register?
My lord, in this first case, there was a technical error. B category has been registered, my lord.
No.
So for a C category,
What was the last date of registration?
But it starts from 3/8 to 12/8 classes.
3/8 to 12/8.
lordship.
Same case like
Yes.
one lady advocate was arguing in the first half.
Yes.
We have disposed it of or what?
Directing the university to consider the representation.
That's what we can do. Is there a similar order? Not.
29th, your lordship will find the order at additional documents I filed, page 12, my lords. There is another affidavit, additional document.
Yes, Mr. Yes, Mr. Rao, what do you say? 12? Huh?
Page 14. Yes, sir.
14.
Same order.
Yes, madam.
3 matters.
1 minute. Page 14, same order, right? Consider and decide. Page 14, certified copy today.
Gotcha. Next 2 matters.
One, two,
2 and 3 also same.
same.
Oblige.
I beg to appear on behalf of Advocate Thomas George Lordship. I beg to appear on behalf of Advocate Thomas George Lordship in this matter.
Whatever.
Lordship, this writ has been filed to consider the petitioner, the NEET counselling which is scheduled to happen in 4 to 5 days, Your Lordship.
Need counseling? Admission to which course?
To the MBBS course, Your Lordship. The petitioner is a meritorious candidate and is a non-local student who has studied his entire education in the state of Maharashtra. And he could not register for the counseling for the state of Telangana, Your Lordship. We are only requesting for, he's a meritorious candidate, Your Lordship.
We don't know.
Yes, Your Lord.
Whether you are meritorious or not, that is considered by Mr. Rao. We don't decide it.
We are only requesting.
This thing, we can't, I mean.
It is to register and participate.
No. We can you can, what is the reason why you did not register between 3/8/23 to 12/8/23?
No, competent authority. Competent authority sits is seeking.
3/2, that rule which is challenged.
Yes.
Yes.
No, not challenged.
No, Lordship, kindly see.
See what sort of relief they pray. Difficult to get, Mr. Rao. Please read page 11. Permit the register online provisional merit list. Permit participate in the counseling B category non-local candidate. So what was the last date of registration for
B category without the 12/8.
12/8?
No, he is not even a local candidate. He is
So
We are asking for
One minute. What did you do from 3/8 to 12/8?
Your Lordship,
Taking chances in Maharashtra, then found out that you are not granted admission, then you are coming here.
My submission, Your Lordship, is.
It's not that.
Your Lordship, here is.
Mr. There has to be a valid justification so that we can direct them to consider your grievance. Why you did not participate between 3/8 to 12/8?
Your Lordship, in this matter, previously the norms of non-local relaxed by this Honorable High Court in the month of August, wherein sitting 4 years, if you studied outside the state.
So you are a fence sitter, right? Waiting for the outcome of
No, Your Lordship.
So that
We
item
were-
number 4 order.
Yes, Lord. Your Lordship, we are-
Delay. We
Your
are
Lordship.
today, Mr. We have passed an order declining the relief to a petitioner who has approached, but
They want sent a mail.
1 minute. But you are not this thing claiming admission as local candidate.
We are claiming as non-local only, your lordship. We are saying under category B only.
Sir, that
We are not claiming as local. We are not claiming as local. We are claiming only under the non-local category.
means you have not read the judgment division rendered by division bench of this court. That's why that judgment deals with local candidates. The rule 33B, if you don't know, and we are not under an obligation to tell you, but still we are telling you, rule 33B of 2017 rules has been read down, and instead of striking down, it has been read down, and it has been said that it does not apply to local candidates of permanent residents of state of Telangana. That judgment, you are not a permanent resident of state of Telangana.
We are holding.
So therefore, division bench, that senior person is correctly advising you to listen to the court, because what we write matters. What you speak doesn't like. Ultimately, we will have final word, right? So you should understand the query of the court. That's why he is guiding you by being patient. Being patient is a big virtue in this profession. We are patient all the time, but we have to pass an order. So we are putting you query because your prayer clause doesn't make any sense, right?
Your lordship may make
1 minute. Everything is time bound. Admission. University had notified that you can register your application from 3/8 to 12/8. Why you did not do it and filed a petition on 2nd September 23?
The only reason, your lordship, is
you are from state of Maharashtra.
No, your lordship, we had found the. We are not. For you, non-local.
Mr. Still, even assuming that you are a permanent resident of state of Maharashtra and entitled to apply under non-local category, understood, right? It's not that difficult. But still you are required to tell us that between 3/8 and 12/8, what were you doing? And from 12/8 till 4th September, what you have been doing?
I shall mention the same, your lordship. Between the month of July and August, the counselings, the state of Maharashtra was ongoing, and the first round and second round completed. And in the second round of counselling, the petitioners secured one seat in a college, your lordship. Thereafter, in the month of August, our Honorable High Court was pleased to read down the rules for non-local state.
No, there you are wrong, Mr. That means repeatedly, second time we are telling you, despite being told, you don't seem to understand. Firstly, you have not read the division bench judgment which we have delivered. And we just now, 1 minute ago, we have told you what is the ratio of that judgment. Still you are saying non-local candidate. That doesn't deal with non-local candidates. It deals with the candidates of permanent residents of state of Telangana.
Yes, your lord.
You are not a permanent resident of state of Telangana. You are arguing that I am a permanent resident of state of Maharashtra and therefore a non-local candidate. Even assuming you are non-local candidate, what were you doing from 3rd August till, and we can't grant you this relief?
Your lordship.
Delay.
Your lordship, now only the petitioner got the opportunity.
Read the now prayer clause. You could have got an opportunity in the month of December. So can we say direct them to admit you in register in month of December? You understand, right?
Yes,
it's all a time bound thing. And they have fixed a schedule. Why R.D. Shetty Supreme Court denied the relief despite laying down the law? Because petition was filed with delay and latches of 8 months. Same thing. Firstly, you are not entitled to benefit of division bench judgment. In a similarly situated cases like local candidates, we have rejected the petition today by saying that the discretion of this court under Article 226 will not be exercised in favor of a person who sleeps over his rights. In case you wanted to participate in the counselling for the state of Telangana, you had to adhere to the time schedule prescribed by them. The time schedule for every candidate alike was 3rd August 23 to 12 August 23. You can't have any reason to say that I will not be governed by calendar of events notified by them and I will come to the High Court and do whatever feel like.
No, Your Lordship, my submission on the division bench judgment is, Your Lordship, yes, it is applicable to the locals who are permanent residents of Telangana. I am only on the point that because the judgment makes it applicable to the permanent residents of Telangana who have, however, studied for 4 years proceeding to this course outside the state of Telangana, they are also considered local if they have studied residents of Telangana. Now, because of that, the number of people competing in the
No. Again, Mr. Have you read it?
Your Lordship
Ask yourself the question, have you read the judgment? Not read it.
This court had read down the.
No. Have you read our judgment? We are asking you a straight question.
I have read, Your Lordship, and in
Then your
limited
impression-
understanding.
The impression is wrong, Mr. Counsel. Impression is wrong. We have not held anybody to be permanent resident. Competent authority of the state government, that is Tehsildar, decides who is a permanent resident. We do not decide questions of fact under Article 226. We cannot decide who is a permanent resident. Therefore, we have confined. What? I mean, we are sitting here to convince you, right?
No, Your
Why?
Lordship. My
You argue your own case. You have not answered the question 3.8 to 12.8. What were you doing?
Your Lordship, the whole crux in the matter here is.
The crux is page 11. Read the prayer clause.
To permit the petitioner to register for counseling of MBBS admissions.
Why? What ground permit?
Your Lordship, we have even sent.
No. Why? You tell us that if the time limit is over on 12/8/23, how should we permit you to on 5th September to register?
We could not have the chance then, Your Lordship, because of that, Your Lordship. We are only
Next
seeking-
year. Chance have next year. You participate in Maharashtra and Telangana next year. Mr. Rao will have different set of rules next year. He will be
Your Lordship, we even
defending different set of rules.
Your Lordship-
Mr. Rao, today, this year being the last year, no?
Yes, sir.
So next year you will have different set of rules.
Yes.
We are asking him to be more vigilant next year. Participate in Telangana and Andhra both and Maharashtra also.
We
already got admission in Maharashtra. If your Lordship permit me, I may make a small.
Yes, please.
My humble submission is, my Lord, when this rule has been read down, a few people who are treated as non-local will become local by virtue of the judge, Tahsildar's permanent residency certificate. Then there are all possibilities for getting a non-local
Vacancy.
vacancy.
So what happens to the last date? If you would have registered.
At that point of time, I don't fit into that.
So if you would have registered on 12/8, we could have considered this argument that if they are treated as locals, you are perfectly justified. Then this seat will fall, it may fall vacant and by a 42 circumstance.
Your Lordship, it's perfectly, that is correct. My humble submission is, at that point of time, I don't stand a chance to apply even, because I don't have opportunity of being a non-local to get into that slot. Now, by virtue of this migration, there is a scope that this applicant stand to get a chance to this non-local quota.
No, Mr. Counsel, today we have passed an order, we want to apprise you. Therefore, thereafter you argue whatever. Today, a similarly situated candidate like the one in the batch which we decided on 29th August, they came before this court on today and saying that extend us the benefit of that judgment 29.8. We have declined, saying that in discretionary jurisdiction under Article 226, relief cannot be granted to a fence sitter.
I really appreciate that point. My only
we have referred to 4 Supreme Court decisions that may be wrong, right, whatever, but we are sure that it will be tested in a forum competent to deal with it. So we will eventually abide by it. But as on today, no justification is forthcoming in the readout from the petition that we have got it. That is 12/8/23 How could you anticipate that we are going to deliver a judgment on 29/8, therefore I will not apply?
It's not that perfectly, I mean, my humble submission is, at that point of time, I'm not eligible in any means to get
Why?
this.
Non-local, no, mister, at that point of time also, today also you are claiming a non-local candidate, that time also you are a non-local candidate. You could have applied between 3/8 to 12/8. Had you applied and sought for a relief now, we would have appreciated this point.
My humble
This is,
submission,
you can't rely on a 42 circumstance, what is going to happen. We don't know, Mr. Rao may have challenged that our order in Supreme Court, what will happen, we don't know. Then again you will file a petition that now my chance has come because order has been set aside by Supreme Court, therefore I am entitled. This can't go on.
Your Lordship,
Correct.
I'm very sorry to.
No, this thing, no, not sorry. Mr. Why we are vocal? Because we believe in giving a fair chance to the council to understand. Otherwise, we will hear him quietly and dictate the order. We are being fair to both of you by disclosing our mind what is going on.
I got it. My only humble submission is to make the ends of justice to a meritorious candidate.
Ends of justice,
That is the
Article 142, Article 1. We don't have that power. And apart from Article lighter vein, 1 minute, listen. Apart from Article 142, lighter vein, Mr. Prabhakar Rao alone has that power to admit you even today or tomorrow. We can't do this thing. You approach him, convince.
I make a humble submission, my lord.
Yes.
I have sent a mail to them seeking, that is an exhibit in this.
That they can look into. But the prayer is for consideration. Prayer is to register, permit to register. Prayer is if you consider the mail.
Yes.
That can be done.
Fair enough.
Mr. Rao, consider their mail. Correct? Yes, Mr. So shall we?
Mail date, it's on page number 26, my lord.
Mail dated?
Dated 1st September, Friday.
Right?
Page number.
Shall we dispose of them?
Yes, ma'am. With this instruction, I'll try my luck.
Yes, better. Mr. Rao is a very magnanimous person, right? He may consider, we don't know. Mark the presence with consent of the parties, matters heard finally. In this petition, the petitioner inter alia seeks a direction to so and so university, Kaloji Narayan Rao University of Health Sciences, Warangal, to permit the petitioner to register for counseling of MBBS admissions for the academics. This sentence further submitted, right? Learned counsel for the petitioner fairly submits that he does not the petitioner does not.
Applies for this patient hearing, your lordship.
May I please?
What to do? Treatment. I want to
Get on. Fine.
Yes.
May I please? As the appeal is arising out of Millet's Land Acquisition Act, Millet's. I have prepared a brief dates and events, Millet's.
Very good. Brief dates. What has learned single judge done?
Millet's claiming parity, Millet's of GO 678. As the land of the petitioners was acquired, Millet's, after following due procedure. Millet's, an award was passed on 1/2/2000. And Millet's, since there was a title dispute between the endowments department and the writ petitioner, dispute was referred under section 30 and 31 to competent civil court by LAOP number 20. That's claiming parity that they have allotted alternative land in favor of one Lieutenant Colonel D.N. Sharma and his son. The petitioner requested for allotment of alternative land in view of the acquisition. Then the court fined for
claiming parity in treatment.
Yes, Mallards.
So why you should not treat your citizens alike?
No, Mallards, ultimately the writ was allowed. The relevant single judge find fault with the manner in which the issue was dealt with, and ultimately at page 36, Mallards, these are the directions. Writ was allowed. Imposing cost of rupees 25,000 Mallards on the other writ.
Must be allowed.
It's 36. I will come to Mallards the next
33.
aspect.
33.
36 Mallards.
Here it's 33. 30. 36 is.
That's 8th line, Mallards.
1 minute. Internal page 33, right?
34 Mallards.
No, the result. Heading is the result.
Yes, the result Mallards at page 33 Mallards. For the aforesaid reasons,
The writ petition must be allowed. It is accordingly allowed. The first respondent is directed to consider allotment of alternative land to the petitioner in an extent of 914 square yards or any other appropriate extent of value equivalent to the value of the petitioner's land acquired. The value of the land to be allotted must be computed as on the date of acquisition notification of the land of the petition. This is how the state computed the value of the alternate land allotted to the Sharmas, and this is how the valuation of the land to be allotted to the petitioner must also be considered. Since all the proceedings under the Act were taken on the premise that the petitioner was the owner of the acquired land, the alternative land should first be allotted in his favor, but subject to eventual claim of the endowment. State must, this is important. The state, Lakshmi may kindly have note this aspect, Manas. The state must do the needful for expeditiously determining the endowment's claim if there be one is still pending. In case it is eventually determined that the petitioner is not entitled to this land, but the endowment is, the alternative land shall stand allotted to the endowments for its benefit. My respective submission is the dispute while the disposal of this writ petition, Malas, already on 1/2/2000 dispute has been referred to Malas competent civil court under 30. As there is a subsequent development Malas on 26/9/2018. Plus LAOP was Malas disposed of. Wherein Malas it was held that Malas the writ petition is not entitled for any compensation. May I pass on those two orders, Malas? In view of this, Malas, the claim of the writ petitioner was rejected by the reference court. And that was not challenged.
Your Lordship, one alternative land was allotted in favor of Sarma. Is the land?
No, what happened to LOP order? Reference
not
code.
aware, Your Lordship.
You say that not aware, give him copy.
Yes, I'll supply minutes.
One more thing, Your Lordship, in this, Sarma was allotted the land that is the land.
Your entitlement will, have you filed an appeal against this order?
They have not filed minutes.
You are not aware, Your Lordship, you are not issued any.
Paragraph 23 onwards are the findings. The ultimate finding is at page 20, paragraph 25 minutes. This court, in view of the aforesaid analysis, holds that the claimant number 12, that is the writ petition minutes, is not entitled to claim the compensation amount for the acquisition of 914 square yards of land by the land acquisition officer, as PW1 has failed to establish the lawful and legal title of his father or his lawful title by way of any registered document in respect of the said land.
Your Lordship, I will verify with my client and submit it. But in fact, Your Lordship, you are not aware with regard to this. And Your Lordship, one more submission is the Sarma was allotted alternate land. His case also referred to the section 30, Your Lordship.
No, so in his case also it was held he is not entitled. Huh? And despite that land has been allotted. Is it your case, mister? Not that. You didn't know.
No.
Please understand. Whatever Mr. Sharma was allotted, it has been implemented. You are claiming parity. He is saying that in your reference, it has been held that you are not entitled to claim compensation and you have not filed an appeal. So do you want to say that in Mr. Sharma's case also reference court held that he has no title despite that they have given him? Not your case.
That is not our case.
And the case set up by the writ petition is basing on an agreement of sale.
Your Lordship, and they have given undertaking.
No. The question of discrimination doesn't arise because you don't have a title. Mr. Sharma had title.
Your Lordship, only question is whether I am entitled for alternative land or not, Your Lordship. That this
You are not entitled in view of this order passed by the reference court.
Monday, Your Lordship, I will get instruction. So that
I leave it.
What Monday? 3 days you cannot find out.
And Mallet's
3 days you cannot find out. Your client stays in South Pole or where? Somewhere. North Pole.
I'm flight of the law.
In Hyderabad only, right?
Not only, but
Whatever. Then find out.
contact the Lordship.
He will find out. You don't have to.
Your Lordship will try to
mark the presence.
Contact your Lordship. Not in a position to contact.
No, that's why.
Monday, Your Lordship will.
No. We'll fix it on this thing. Yes, madam. Right. This intra-court appeal has been filed against order dated 23/11/2006 passed in the writ petition by learned single judge. Paragraph facts giving rise to filing of this appeal in nutshell are that the land belonging to the petitioner measuring 914 square yards situated at Somgam, Langer House,
My lord, that was
the
ultimately
petitioner filed a paragraph. The respondent filed a writ petition, namely WP number 7551 bar 1998, challenging the notifications issued under section 4.1 and section 6.1 of the Act. In the said writ petition, an interim order was granted on 12/1/1998, which was made absolute on 9/11/1999. Paragraph. During the pendency of the said writ petition, the respondent made an application seeking allotment of an alternative land. Thereafter, during the pendency of the petition, correct? Right. The
one date is missing, my lords. 1/2/2000, what has been passed, my lords, and it was referred to civil court.
Delete, madam.
On 1/2/2000.
1/2/2000. On 1/2/2000,
Yes.
an award was passed
And
to
the,
stop the petitioner being dissatisfied with the quantum of compensation.
not the petitioner, my lords, there was a title dispute. My lords, there was a claim by endowment.
Alright.
So the land acquisition officer
Full
referred
stop.
the dispute.
Delete. The award was passed on so and so. Since there was a dispute with regard to title in respect of land in question, the dispute was referred under section
30 and 31
30 of the Land Acquisition Act
by LAP number 20.
for adjudication before the civil court. Paragraph. Paragraph. The petitioner filed a writ petition in which memo dated 25/1/2023 was challenged, by which his claim for allotment of an alternate land was rejected. Full stop. The learned single judge, by an order dated so and so.
But your lordship, that rejection
One
was
minute.
challenged. Your lordship, again, that rejection was challenged in the writ appeal, your lordship, that was set aside and matter was remanded. This is the, they have
One
filed
minute.
that
Don't
writ-
interfere. Don't interfere when the order is being passed. Filed a writ petition. Right? The petition was dismissed.
Writ petition was dismissed against her to carry the
Of
matter.
the writ petition filed by the respondent was dismissed, against which he filed a writ appeal in which the he filed the writ appeal. Full stop. A division bench of this court remitted the matter for reconsideration. The learned single judge thereupon, by an order dated 23rd of November 2006, has allowed the writ petition and has directed the appellants to allot an alternative land. Full stop. In the
Subject to
aforesaid
adjudication of dispute, my lords.
subject to adjudication of the dispute pertaining to title. Paragraph. Which was pending before, which was pending before the reference court. Paragraph. When the matter was called today, learned so and so GP for revenue.
Attached to advocate general.
Whatever, has produced a copy of judgment dated 26 September 2018, passed in LAOP number 20/2020, by which the question of title has been adjudicated, and it has been held that the respondent stroke landowner has no title in respect of the land in question. It is therefore contended that it is also pointed out that the petitioner has that the respondent stroke landowner has not filed any appeal against the order dated 26 September 2018. It is therefore contended that the petitioner is not a respondent landowner is not entitled to allotment of any land. Paragraph in view of aforesaid submission, learned counsel for respondent prays for adjournment to enable him to seek instructions and to make a statement whether the order dated 26 September 2018 passed by reference court in LAOP number 20/2000 has been challenged by him in an appeal. And if so, what is the status of the appeal? List on Monday, 11 September 23.
Pleasure.
There is nothing actually we could have disposed of. He obviously has lost. That's why he is not contacting the respondent. He will find out Monday. He will tell us that. See, you only tell us whether you have filed an appeal or not. Then you agree that if you have not filed an appeal, it goes nothing.
Even if they prefer an appeal, that would be subject to the result of that appeal. Even if they prefer.
No, but you are saying that it has not filed. They have not filed.
They have not filed.
Let's
only the endowments have filed. Both the claims were rejected.
Let's see.
Pleasure.
See. Application failing which. Yes, none for the. We are not asking you who is appearing for respondent. None for the appellant. Despite write his name for respondent, despite opportunity being granted on 28/8/2023, to make an application seeking substitution of LRs of diseased appellant, no application seeking substitution.
Interim order passed on 21st May 2008. Directing the interim directions till the disposal of the writ petition. Writ petition is pending before the single bench.
Single bench?
Against the
What the list survives.
against the interim of the order.
So we have to hear.
And in fact, you lords may close the writ appeal and direct the writ petition to be taken up for hearing. That would. Because the interim order is till the.
No, what happens to WP 2180?
Your lordship still not constituted, your lordship.
180 because of the interim directions granted in this division bench order, unless my petition is decided, but they would not get the relief. So both have to be tagged on before the single bench.
Writ petition number 13618 of 2022, your lordship.
Item gives 64 item.
This is a connected matter which a senior counsel is saying.
Correct, right? He's making a correct submission, right?
Yes, your lordship, a fixing of the rotation of the board of trustees, your lordship, year by year.
No, not rotation.
Interim order date
What he said?
21st May 20.
2008. Are you aware, madam? 21st May.
Lordship, another writ petition has been filed by the learned senior counsel, lordship. Writ petition number
She has
313.
not understood what you have said. She has been fed into that adjournment has to be sought and something says. Did you understand what he said, madam?
Yes, your lordship.
What did you get?
Senior counsel said that the other writ.
No, senior. What did he say?
said that other writ petition,
What is the interim stay as prayed for means? Which writ petition, Mr.?
That is 7040.
it is not been.
7040.
40 of 2008.
8. So it comes before this bench or any
Before
other
the single bench.
single bench.
Against the interlocutory order, writ appeal.
We request the learned single judge to decide this WP 70